The June meeting of the California Law Revision Commission will come to order. Everyone has the minutes of the last meeting in the materials that were circulated. Are there any additions or corrections? Hearing none, is there a motion to approve?
So moved.
Is there a second?
Second.
I will call the roll. Commissioner B,
I think I have to abstain because I wasn't at the meeting.
Okay. Commissioner Carrillo is not here. Commissioner Carrion is not here. Commissioner Kubas.
Abstain as I was not at that meeting.
Okay. Commissioner Hebner, Chair Hebner,
Aye.
Commissioner Jenkins,
Aye.
Assemblymember Calra is not here. Commissioner King,
Aye.
Senator Roth is not here, but I'll get to that in a minute. And Commissioner Simpson.
Aye.
Thank you.
Thank you. We'll turn to the executive director for items 2 and 3 on the agenda.
Sure, I just have a brief update on things that are going on. I'm happy to announce that we will have a new, or we do have a new member on the commission from the Senate who is replacing Senator Roth. We thank Senator Roth for his long-term service on the commission. We are very excited to welcome Senator Blake Spear. Unfortunately, she was not able to be here today. She's hoping to be at the next meeting so everyone can welcome her. Kristen and I did have an opportunity to meet with her and her staff a couple days ago, and she is very enthusiastic about service on the commission. So we're very much looking forward to that. Turning to the budget and the continuing issues with the budget, there was a budget passed to meet the June 15th constitutional deadline, but as in past years, budget negotiations continue. So we as staff are continuing to monitor it, and we'll let you know if there's anything that you need to be aware of. So far, we're so good. And then turning to the August meeting, there are a few administrative matters that are typically on the August meeting, but we have a very full agenda. We have 3 export reports on relating to antitrust on our next agenda. So I think that we will recommend to move some of those to the October meeting. And we will work with the chair to make sure all that runs smoothly. Okay, and then next on the agenda is commissioner suggestions. Do any commissioners have suggestions? Okay, hearing none. Okay, now we can move on to the commission handbook. Kristen is going to present that, and I see that you have a mic. Okay, good.
Yes, I'm all set. Thank you. So the memorandum 2024-22 presents some revisions to the commission's handbook. At the last meeting, the commission directed staff to revise a handbook to make clear that the commission views itself as an advisory body for the purpose of the teleconferencing authority. We included on pages 2 to 3 of the memo some language to do that, and also to specify when the commission might conduct in-person versus teleconferencing meetings, and some related language about compliance with Bagley-Keene requirements. So that was the main purpose of the memo, but while we were doing that, we also identified a few other provisions of the handbook that needed to be updated. So there were 2 other items that are for the commission's decision. One are some revisions to the provision about electronic communications and record keeping. Those are on pages 6 to 7 of the memo. And that was a relatively minor revision, but we just wanted to call it to the commission's attention about the obligation to provide electronic communications to staff at the end of term or before the end of term is what we wanted to clarify. Either way works. Commissioners can forward things as they come in or at the end of their term. And the last item is there's just a number of minor updates that we propose. Those are all proposed consent items. I don't plan on talking about those here, but if there are any questions, I'm happy to address those. The commission is welcome to take up those decision points all together if they approve the staff proposal or take them up individually. And there is one informational item that we've included. We understand that commissioners have been getting some questions about, they've been receiving requests to speak with individuals outside of commission meetings. So we wanted to provide some information about the applicable rules and handbook provision that relates to that. There is no prohibition on commissioners speaking with people outside of meetings about items on commission business. The one thing we do want to caution the commissioners about is the possibility of serial meetings, which would be a situation where an individual meets with cumulatively majority of the commissioners on an issue. That is a problem for Bagley-Keene purposes. And so there's some guidance provided in the memo about, things that the commissioners should be aware and thinking of. The handbook also currently contains a rule that asks commissioners to let staff know about who they're speaking with, and if there is a written communication, to provide that to staff if possible, and that would help track that issue. So if there are any questions, happy to address those, but otherwise.
Before we move on from that, does any commissioner have a question about the last part of the report? About the serial meeting and the importance of notifying staff if you've had a conversation? Hearing none. Rick?
Yeah, just a techie thing about the approval of actions. This says that if staff asks if there are any objections, then, and there aren't, then staff can just go ahead and assume it's a unanimous vote. I personally would, and maybe it's because of my years, down at the Capitol, I'd prefer that it be handled more like they do in a committee, where the chair says, rather than sort of staff doing this administratively, the chair says, is there any objection to unanimous roll call? Hearing none, seeing none, ayes 7, noes none, or it's approved by unanimous consent, something like that. So it's an official action of the chair rather than staff would be my suggestion.
Yeah, I have no objection to that. That seems perfectly fine.
So just, analogously to how they do it in a committee.
Are there other views on the point raised by Commissioner Simpson? Hearing none.
Can I just ask one clarifying point? Do you think we need any revision to the handbook to reflect that? I was just looking at the
Well,
language.
yeah, in subdivision E on the top of page 4.
Okay.
Rather than saying if no something about to the effect that if nobody objects, the chair can ask if there is objection to unanimous consent, and if there's no objection, it'll be deemed approved by unanimous consent.
Okay, so just to clarify that there's a role of the chair in that process.
Yes.
Okay, we can propose language to implement that, and if that's okay with the commission, run that by the chair. And
Well, if you've written the language down, can't we approve it now?
okay, so
It's only that one section. It'll be more efficient if we can do it now.
okay. So the
And
action,
while you're working that out, is there any comment from members of the public on this agenda item? Hearing none. Back to you, Kristen.
okay, and so what I'm going to propose for this is actions for an in-person meeting may also be taken by unanimous consent. If the staff asks whether a certain action should be taken, the chair can ask the commission whether anyone objects. If no commissioner objects after having been given an opportunity to do so, the action is deemed approved by unanimous consent of those present.
Sure.
Okay,
That works. So if the commissioners just want to take a vote on that, we will incorporate that as a staff proposed language. If they want to approve the staff proposed language in this memo,
yes, with that read into the staff memo, is there a motion to approve the staff?
So moved.
Is there a second?
Second.
okay. and I
Please
will
call the roll.
call the roll.
Yes.
Is there objection to
Commissioner,
unanimous consent?
Well, let's call the roll on whether we can take that.
Oh, okay.
And thereafter, we'll shortcut.
Got it.
all right, let's start again. Commissioner B,
Aye.
Commissioner Carrillo and Carrion are not present. Commissioner Kubas,
Aye.
Chair Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye.
All right, thank you.
Very good. Kristen, anything else from you?
That is it. Thank you, commissioners.
Okay, agenda item 3.
Sure. The next agenda item is update on our legislative program. We do have a memo that Sarah will present later relating to the administrative subpoena, AB 522. We do have a couple bills that are pending in the legislature, and we have our resolution of authority that Assemblymember Calra is carrying, and that is making its way through the legislative process. And thank you again to Assemblymember Calra, who is also a commission member, for carrying that for the commission. We have some technical legislation relating to outstanding trial court restructuring reforms and conforming revisions for recodification that are also making their way through the legislative process. We do have 2 potential new assignments that continue to make their way through the legislative process. AB 1906, which would be a study on removing the terms dependent adult and dependent person from the California codes. And AB 2125 is a study relating to recusal of judicial officers. Previously, the bill sought to make changes in the law relating to recusal of judicial officers. The bill has now stripped out that language, and all that is remaining is the study that would be assigned to the commission. Are there any questions?
No.
Okay. So next up, we have our special order of business on antitrust. We're 2 minutes early, but it looks like everybody is here, so we can go ahead.
Yes.
Okay, so we do have a number of folks here today. We have 2 expert reports being presented, mergers and acquisitions by John Quokka, Professor John Quokka and Professor Krishnamurthy, and then the expert report on technology platforms being presented by David Kesselman and ABL Garcia. We are very grateful for their ongoing dialogue with us and being here physically present in the room. I think that makes the dialogue just a little bit easier, although we do very much appreciate the opportunity for folks to appear by Zoom when it's necessary. This is our second round of looking at the expert reports. The final round will be at the August 15th meeting. Throughout the process, staff has been actively encouraging all interested parties and stakeholders to submit public comment. That seems to be ramping up a little bit, as anybody who looked on our webpage can see. Even up to about 5 o'clock last night, we were posting additional public comment on the website. We really very much appreciate the public comment. It was nice to see that we have sort of some regular citizens also writing in. So it looks like the awareness of the study is growing. So we're pleased to report on that. Does anybody have any questions for me at this time? Okay, so first up on the business, our special order of business is an update on the Uniform Law Commission's antitrust pre-merger notification draft that will be presented by Dan Robbins. He tells me he'll take about 10 minutes and then we can open it up for questions from the commissioners. So with that, Dan, can we turn it over to you, and are we ready with the slides? Just give us a second here to work out our technical issues. All right, we're in business. Thank you. Thank you, Dan.
Great. Thank you. Thank you, commissioners, for allowing me the opportunity to update you on the work of a fellow commission in California and also commissions around the country. Next slide. Okay, great, thanks. Just to give you a brief and I've been a member of the California Commission on Uniform State Laws since 2007. Every state has a similar commission, and they work together under a national body called the Uniform Law Commission. It represents the 50 states, DC, the Virgin Islands, and Puerto Rico. The purpose of the Uniform Law Commission is to draft and enact state laws where uniformity is important. So our top product is probably the Uniform Commercial Code. I'm pleased to report that California adopted all the recent revisions last year. The Uniform Commercial Code covers sales, leases, financing, and it's a good example of the need for uniformity. So if I sell a car to somebody in Pennsylvania, the buyer and the seller should know what the rules are, and they should be similar. We don't want anybody to be surprised by an unintended result. We've also done work like the Uniform Trade Secrets Act, and we've enacted 6,000 laws in the country. I've been pretty involved. I was the chairman of the board of the national body from 2019 to 2021. I was elected president of the national body and served from 21 to 23. And then when I attempted to retire, I became the chair of the Antitrust Study Committee and also the Antitrust Pre-Notification Act. Those of us who have served the state on a commission know that it's great opportunity to advance the law and serve the public. However, almost all these jobs I'm aware of are non-paying. And I have a family of 5, including several in college and a mortgage. So I have a day job. I just wanted you to be aware of that. My day job is at the Motion Picture Association. I'm not in government affairs or a lobbyist. I am an in-house compliance lawyer. Part of my job is to make sure that all of our employees who work in over 100 countries know what the antitrust laws are in each of those countries, and just as important, to comply strictly with them. So my job is to teach them and stay on top of them. And then I have some other things that I do as well, unrelated. Next. Great. So let me give you a little context. So we've had a federal merger law since 1914. And the states have been able to enforce it. In fact, our state has done some great work in that space. We've won a unanimous decision in the United States Supreme Court in the late 80s. But for a long time, the enforcement would often happen after the merger was complete. And that's a little bit like trying to unscramble eggs in an omelet. And there was a recognition that that wasn't an efficient process. So our federal friends passed the Hart-Scott-Rodino Act in 1976. That requires parties to a merger to file a detailed form and a bunch of supplementary material with the federal enforcers in advance of the deal closure, so that the federal enforcers can study the transaction and determine if there's problems and either seek changes to the deal or oppose the deal in court, or if there's not a problem, to let the deal through. There's a lot of material that comes in with that filing. For example, when management makes a presentation to the company's board of directors about the merger, that's included in the filing, so the government can see the same thing the board of directors saw. As an aside, you should know the Federal Trade Commission is in the process of changing the content of those submissions. They're seeking to increase the amount of material that companies give to the government. The uniform law doesn't affect that. Whatever the result of that government process is, that package, which I think will include more about the merger's effects on workers, all that package will be given to the state AGs, pursuant to this law. Importantly, the Hart-Scott-Rodino Act makes these filings confidential. This is critical for the business community. The filings have lots of detailed financial, confidential information in them. And, if they were out in the Los Angeles Times, that would harm the company. It would allow the company's competitors to compete unfairly. It might create insider trading. There's a Pandora's box of problems. So these filings are confidential and FOIA exempt at the federal level. So that gets us to the problem we're trying to solve. The state AGs have the authority to enforce against mergers under the Clayton Act. What they don't have, though, is they don't have this information. This information gives notice, so you know what's going on, and then you get a lot of details about it, so you can evaluate it. Today, that doesn't happen. States find out about mergers secondhand or through the press. Then they'll ask the parties about the information, and some parties cooperate, but some parties don't. And there's subpoenas, and there's litigation, and delay, and expense, and that's what we're trying to resolve. Next. So that's the spirit of this act. It's really a good government act. We are trying to, for the state AGs, we're trying to get them this material at the same time the federal government gets it, pursuant to the same confidentiality restrictions that our federal friends have. And also we're trying to cut down on this collateral, useless litigation with all these subpoenas. To pass a bill, it's always easier if it's balanced. And so on the business side, the benefits are that the filer knows in advance if there's going to be problems. Today, and this happened in the big California case I mentioned, the American Stores case that I did research on when I was in law school in the 80s. So it got a fond place for me. But today, it doesn't work out that way. The federal government can approve something, the states can find out later and be behind. And so this allows the business community to have certainty, enhanced certainty, and also to reduce their litigation expenses. Oh, sorry, next slide, please. So this idea was actually suggested to us by Diana Moss. You heard from Diana at the last meeting. She's in charge of competition policy at the Progressive Policy Institute. We thought this was a good idea on her part, and so we pursued it. We created a drafting committee that is balanced. I wanted input from all sides. So at every meeting, we had the United States Department of Justice Antitrust Division, we had the Federal Trade Commission, we had representatives from the California AG's office, the New York AG's office, and just to make sure it's not a big state thing, we got the North Dakota AG's office involved as well. And at the same time, I've involved 12 state chambers of commerce from around the country to make sure I get balanced feedback. The AGs, I think, generally are supportive. We've heard good things. They want this information sooner. You'll see on the slide, they did a filing last year where they noted that this act would be a non-burdensome mechanism for states to receive access to the filings at the same time as our federal friends. And the idea is to facilitate early information sharing and coordination between all the states, because we don't want states duplicating effort with the federal government or with each other. Balance, again, is key. This is sort of my side note as a person who has a government hat on. In your process, I tried to help as well. I reached out to Senator Gianaris and helped set up the session in the fall. I also brought someone from the New York Chamber of Commerce, so you could hear both sides about his bill. I tried to do that with Senator Klobuchar, but I've been less than successful. I apologize. The staffer left last fall. And so my just side advice is always good to seek balance. I think some of your working group reports have that, others don't. So make sure if there's holes that you seek to fill that with input from both sides. The reason I say that is I've been involved in a lot of these other bills too, and the ones that are imbalanced have failed. So the New York bills failed 4 times, Minnesota's similar, failed twice, Maine similar, New Jersey, Pennsylvania, Maryland. These are all instances of failure. I think if you want to have a passable bill, it has to have balance and take in everyone's input. Yes.
Question, you talk about both sides. Do you believe there are only 2 sides on this issue? Or would you flesh out a little bit more about the kind of input you're suggesting? Is this really a bipolar world?
So on this particular act, it's mostly about the AGs and the business community. This is a little easier, I admit. There's primarily 2 sides there. I think in this overall framework, it's more complicated. I've seen good input from our union friends, from folks that want a significant reform. I've read all the hundreds and hundreds of pages of material you've received. I feel for you. There's a lot of stuff there. You've had good input from the tech community. The places that I haven't seen something, I haven't seen any responses on the healthcare side. I haven't seen any responses in the agricultural community. They were accused of being a concentrated sector. So I think you're just getting some more input there. It's workers, it's enforcers, various types of businesses, and the businesses are often quite different. So capturing all that, I think, would be critical.
Commissioner
Simpson? Yes.
Is the nature of the enforcement of the, I guess, merger laws different or the same between states and the federal government?
So today, both can enforce the Clayton Act, the federal law. When it was drafted, it was intended to allow the states to do that. And then the case I mentioned, the American Stores case, was, you may remember this merger. There was before Kroger Albertsons, there was Lucky Alpha Beta. And they had planned to merge, and the Federal Trade Commission approved the deal. But California disagreed, and we took that case to the Supreme Court and won a unanimous decision holding that California could not just enforce, but they had injunctive powers as well against the merger. That the deal eventually settled when the stores divested a bunch of stores in California. But we have got the full spectrum of authority there. Some states may have their own merger laws. I know that we don't. But generally, I think it happens under the federal Clayton Act, and in California, we've had some great success there.
So I guess I'm curious, is it up to the state as to what evidence or the nature or the size of the mergers before they would become subject to enforcement? Is that?
Yeah, the states,
as it varies from the feds.
Right. So the way the HSR works is it's looking at bigger deals, because bigger deals are more likely to have adverse competitive impacts. And so that threshold now is about $120 million. If your deal's bigger than that, you have to file. But it's certainly possible for smaller deals to have adverse competitive impacts. You could look at it if you had a small market, and all the anesthesiologists in the market were merging, then you could have a problem that's way below 120 million.
And that would be enforceable under state law, but not federal?
No, you could enforce under the Clayton Act.
Yeah, okay.
Yeah, because it's focused on the market. So if the market is small and the adverse impact there is significant, then you can target it in that way. those cases don't get the same kind of press.
Right.
That, like Kroger Albertsons gets big press because we all know what those are. We didn't know. I couldn't name an anesthesiologist as I sit here.
Got it. Okay, thank you.
Great. So just, sorry, next slide. The mechanics, the way this works is we're trying to make sure that the states that are most likely to have an issue get this information right away. So if you're emerging party, you must file all of your materials with the state where you have your principal place of business. That's a term we borrowed from federal diversity jurisdiction. It's well understood. There's a unanimous Supreme Court case from 2010, the Hertz case, that sort of explains the parameters of what that means. And then also, if you have more than $24 million in net sales in any other state, you have to file in that state as well. So they have notice. We're trying to get the information to the states that are most likely to care, because we recognize there's 2,000 of these deals every year. And if you're in Vermont, you probably don't want to see all that. So that's the targeting piece. There's no filing fees for the act of giving the information. This was important feedback from the business community. They didn't want to have 50 state laws with 2,000 transactions where they had to pay X dollars every time. They told me it's a non-starter, all 12 chambers of commerce. So there's no filing fees for this material. That does not mean you can't collect filing fees if you've got a statute that allows for you to collect fees when you have an investigation. This doesn't affect that. This doesn't overrule that. This is only about the fee for actually taking the material. The confidentiality obligations are the same as the ones in the federal law. And importantly, we have reciprocity. So let's say, for example, New York gets a filing and they think, oh, this California may have an interest in this. The New York AG can share the filing with California AG or any other state that's passed the act and has the confidentiality protections. That's our goal, is to encourage sharing and efficiency. Next slide. So just some potential objections. When you're in the middle of this, you'll hear, criticisms from both sides. If both sides are beating you up equally, then you've probably done a good job. We heard, well, this, it's a burden on the AGs to get all this information, the burden on the merging parties, but it's the exact same filing that the federal government gets. It's tailored to merger analysis. This act eliminates all those unnecessary subpoena fights. It gives earlier notice. You don't have to look at every merger. And if I were running the antitrust division, I wouldn't in a state. I just look at the ones that I know affect my state more. And I'd talk to all my other AGs and would, share some of the responsibilities. Very important for California. I want you to know this does not adversely impact the rules we have. We have a healthcare merger statute from 2022, and last year we did one for pharmacy and grocery stores and such. This doesn't affect those. This doesn't overrule those. This only supplements those. So the state gets all the information it gets under those. This doesn't restrict it. This only allows, for example, in a grocery store merger, if there's something going on in Florida that might be related, you can get that too. And then, sorry, one more. So just in terms of process, we finished the drafting process. We've candidly have taken lots of input from the enforcers, federal and state, and lots of input from the business community. And this is a balanced approach. Honestly, I know some enforcers would like more and some business folks would like less. But I think we've hit the sweet spot. The act now goes to the annual meeting of the Uniform Law Commission next month, where it'll get voted on by all 50 states. And if it's passed there, then it will be sent out for enactment in January of 25, probably in about 20 or so states, but we haven't fully figured that out yet. So thank you, and glad to answer any other questions. I appreciate your attention and engagement.
Are there any other questions from commissioners? Hearing none.
Very good. Thank you.
Yeah, the next working group is mergers and acquisitions. And we welcome Professor John Quokka and Professor Prasad Krishnamurthy for all the contributions, as well as the contributions of your group. We're hoping, the commission mentioned at its last meeting that they're hoping to have dialogue and for this to be interactive. I know we talked to you about it, so we're hoping that all goes well. So thank you.
And before you start, on behalf of commissioners, I'd like to thank all of the working groups. We know you've put an immense amount of effort into these voluminous reports that our staff likes us to read before meetings. You should assume that we have read them. I appreciate professorial approaches to issues, but I have to tell you, as a law student, I lost focus almost immediately. So if you're about to give us a lecture, you're wasting your time. It would serve our purposes better if you assume we read your reports, and what we really would like to know are your senses of where the inflection points are. Where are the policy decision points? What are the things you really want us to be thinking about? And framing what you do that way, rather than giving us the second-year law school antitrust lecture on this section. Having said that, if any commissioner has a question as we go, no need to seek leave. Press your button and ask your question. So this is as interactive as we can make it. And the executive director will flag when we've got about 5 minutes left so that we know we're running out of time. Thank you.
Good morning, Chair Hebner and members of the commission. My name is John Quokka. I am professor of economics at Northeastern University in Boston, and one of 5 members of the working group on mergers and acquisitions. Together with me today is Professor Prasad Krishnamurthy, who will introduce himself in a moment and mention the other members of the working group who are not present. Let me begin by saying that we appreciate the opportunity to conduct our review and offer our recommendations to you on California policy toward mergers and acquisitions. This is an important moment in antitrust. There are many concerns about the state of competition. At the federal level, there is matching those concerns, new agency leadership, new initiatives, new merger guidelines, and perhaps, though not certainly, resources to execute on all of those matters. This is certainly an appropriate time for California to review its antitrust statutes for their adequacy as well. I myself have been both a researcher and a participant in these issues. I've written and published extensively on mergers and merger policy. I have worked and consulted for both the Antitrust Division of the Justice Department and the Federal Trade Commission. I've also consulted for the states, including the state of California, on a variety of antitrust matters over the years. So I'm quite familiar with the interplay of state and federal policy. And most recently, I served as chief economist to Chair Lina Khan of the Federal Trade Commission. At her invitation, I came on board to assist with the drafting of the new merger guidelines. And we heard in that process, as you have here, from many stakeholders and sought to fashion policy that reflected their concerns and fully reflected at the same time the best of modern economics and sound law. To be clear, I'm no longer at the FTC. I've returned to Northeastern, and so I speak only for myself. Professor Krishnamurthy and I will be jointly offering our presentation and invite, obviously, your comments. We hear your admonition clearly, and we welcome your comments at any point along the way. But we do have an outline of presentation just to walk through our report and some of what is in the document. And in addition, at staff's urging, some of what may not be in the document, but represents the discussions and deliberations that we had within ourselves. So with that, let me turn it over to Professor Krishnamurthy for his presentation.
By teaching antitrust, which I've done for almost the last 15 years, I work largely in the area of financial regulation and financial institutions, but with a strong focus on competition. I speak for myself, though we'll be very shortly joining as an advisor to the Treasury Department on issues of financial regulation. The other members of our committee are Rich Gilbert, Distinguished Professor of Economics at UC Berkeley, and Daniel Sokol, Professor of Law and Business at USC, and Guofu Tan, Professor of Economics at USC. So you have asked us to not tarry too long on kind of basic issues of antitrust. So just to begin, we are largely concerned in merger enforcement with horizontal mergers between competitors, and vertical mergers that involve either upstream or downstream firms, or firms that do complementary things in some way or the other. The key federal statute is the Clayton Act. That's what federal enforcers enforce merger law under, but it's important to know that state authority exists to enforce the Clayton Act. Any merger that's deemed anti-competitive in the state of California can be enforced by the state AG's office today. The only issue is that they would have to bring the action in federal court. And so in one of the, I would say, major decision nodes for which to think about in terms of building out a state merger enforcement is whether there would be, what would be the advantages and disadvantages of proceeding under state court, which with probably a very similar substantive body of law. Most US states have not reinvented antitrust law whole cloth in their state merger enforcement. And most of the time, federal precedent guides the state decisions. So state versus federal court is a very important decision node. Under California, we have the Cartwright Act, but unlike the Competition Act in many states, it doesn't provide independent authority for California to proceed under state law in challenging a merger. I want to say, and we want to say something about schools of thought without, again, without lecturing on the history of antitrust thought, because people are more or less in the antitrust community beholden to one of these frameworks. And so any decision about what to do is informed by a philosophy or vision of the world. And so we can think of antitrust as being divided into three rough camps, and these are sort of historical. So in the 60s, antitrust liability was perceived very broadly by the courts, 50s and 60s. And the Chicago School is a reaction against that. And it's one that emphasizes that markets are often self-correcting, that mergers, for example, are often efficient, and that regulators make mistakes. And so there are often errors whereby a merger will be blocked, even though that merger would be beneficial to consumers. Also an emphasis on consumers' well-being, as opposed to, for example, the well-being of small businesses. Now, there was a reaction against the Chicago School, largely by learning in the economics community that strategic interaction between firms can lead to anti-competitive outcomes, and this can persist. The market will not correct it. And this is reflected in this sort of post-Chicago view. I think that view is very broadly captured in the 2010 merger guidelines, which were in place before the new ones. And they are, for example, the guiding principles of the European merger guidelines between competitors. There is very little daylight between the European approach on paper and the 2010 merger guidelines. So this was the dominant view within the economics profession. and had been the dominant view up until very recently. But the neo-Brandeisian view, I would characterize as a concern that there is under-enforcement even under the prevailing norms, greater corporate consolidation, rising profits among firms, less viability of small businesses, a view that all of this characterizes the US economy. And so antitrust enforcement needs to be more robust in response to that. And as a
Professor,
legal-
may I ask you to hold for just one moment?
Sure.
I'd like to thank Senator Blakespear for joining us. Professor, please continue.
And whereas as a kind of policy matter, this new view views antitrust not just as about competition, but also about democracy, about industrial deconcentration. As a practical matter, I think and Professor Kwoka can corroborate me on this. There's been just a greater focus more recently in this view on viewing competition as being closely related to industrial concentration. So if we just look at market shares in a industry, if we look at the concentrations, the amount of shares that are taken up by the larger firms, that is a good enough proxy for us to conduct antitrust law. And so we can operationalize this broader view by focusing on concentration. And I think the new merger guidelines reflect that to some extent.
Let me pick up at this point and corroborate, as Professor Krishnamurthy pointed out, there are various schools of economics and law, for that matter, on these issues. But in recent years, there's been a growing concern about the state of competition in many U.S. markets. Next slide, please. And this has been documented in a lot of different ways. There are a large number of industries that everyone is familiar with that have undergone substantial consolidation. Rates of new firm startups, which are a source of continuing competition and innovation, have declined over the past 10 or 20 years. And the rates of economic profit are at historically high levels. This has given rise to a concern about the diminished dynamism of the US economy. Economic studies, including some that I've written myself, show the contribution of lax merger control to that rising concentration and diminished competition. My study and a couple others that economists have done have examined a number of mergers that have been approved by the federal agencies, horizontal mergers rather, and have shown that a large fraction of these have resulted, despite investigations of the agency, in higher prices post-merger. My own results show that more than 80% of cleared mergers have resulted in anti-competitive effects, meaning that either they were not detected or the standards of review were so high that they were nonetheless cleared. With respect to vertical mergers, scarcely any of these until the past 2 or 3 years have been challenged at all by the federal agencies. There have been few, if any, challenges to those affecting worker wages and working conditions. And there have been scarcely any challenging those that have eliminated potential or nascent competitors, in contrast to those that have addressed existing competitors. So those are 3 blind spots, areas and large areas, important areas, vertical mergers, wages, and potential competitors, that the current standards up until the recent past and practice have simply overlooked. In addition, in the tech sector, concern has arisen because until, again, the past 2
Professor, quick question. Is the effect of a merger on wages a criterion under which the feds, I guess, or states can stop mergers?
Yes, it is. The merger statute says that any merger that substantially lessens competition is subject to the law. So as opposed to a product market, things you and I may buy,
Mhm.
the market here would be the labor market. And any distortion due to market power, or in this case, the power of a company to suppress local wages, is just as subject to federal law as a product market merger. So for example, and this has come up, a local hospital may acquire the only hospital in the area.
Right.
And prices may rise, but in addition, it may suppress the wages of workers who offer their services, not only now to one remaining hospital as opposed to two that previously bid for their services.
So wages are deemed to be a form of market in the review.
Excuse me, yes.
Okay, thank you.
Exactly. It's,
If I could
there's,
jump in, John, would you agree? That's true in principle, but I don't know of any merger that's ever been challenged on those grounds. Maybe very recently, there might have been a change.
so current mergers are routinely examined for that possibility. And that possibility has been an integral part of the FTC complaint against Kroger or Albertsons, for example. So there's a section in there that says, in addition to everything else, this raises a concern about the effect on worker wages. And hospital mergers too, this is being pursued.
Okay.
Again, in my time at the FTC, without disclosing anything that almost everybody, it wouldn't be a surprise to anybody, mergers that are passed before the agency, passed through the agency, are now routinely being investigated for whether they have effect on worker wages and working conditions as well. Tightening overtime restrictions or leave policies are also an adverse effect that can result from greater monopsony power, buyer power.
Professor, in that regard, so far in the materials that I've seen and what I've heard, sometimes consumers and wage earners seem to be treated as two different populations. Is there a place we can look for a net analysis, since consumers and wage earners are largely an overlapping set of each other? Or is the way antitrust structured to treat them separately?
So this goes to the question of interpretation of the statute. The statute for a long time, as my colleague has pointed out, was to interpret the statute in terms of consumer surplus with a focus on product prices and quality of products and the like. But the statute talks about lessening competition in any market. So there's a labor market, and if competition is lessened in that market and adversely affects conditions, the equilibrium, the optimal previous price in that market, then it's equally subject to the antitrust laws. So the statute is really framed in terms of lessening competition in any relevant market. Now, what's common to workers on the one hand and product prices, consumer effects on the other, is sometimes called trading partners. That is, who's on the other side of an increase in market power. This can be farmers in selling their product to meat packers. These can be ranchers doing the same thing. This can be nurses and others who are in local labor markets. All of those are subject to potential increases in buyer power. So the language of the law doesn't require choosing consumers or workers or wages or prices. It's a lessening of competition, however it manifests itself. So the merger guidelines is an effort to take that broad language, the new merger guidelines, take that broad language and turn it into operational guidance in different types of markets, product markets, labor markets, monopoly power, and other markets. Does that answer your question, at least in part?
Close enough for now. Thank you.
Okay. Happy to have this discussion offline another time if you wish. So again, my last point here was that the tech sector, over the past 20 to 25 years, the 5 major tech companies of great importance here in California and to everybody, to be clear, have acquired more than 900 companies until recently without a significant review. I'm not saying which or any of them required to be challenged, but they were simply passed over without significant antitrust review at all. So the new merger guidelines, as referenced and on which I worked, have been updated in part to deal with blind spots in the old antitrust paradigm, as well as some of the new challenges represented by, say, the tech sector and other parts of the economy that have grown substantially in the preceding years. So this I will go through these very quickly because some of these I'll talk about a bit more, and the rest of them we can discuss if there are any questions. But the guidelines were intended to build out the framework for how the term lessening competition can result in harmful adverse effects on competition in different types of markets. So the guidelines have a section that sharpen, as I say, the standards for horizontal mergers, set out criteria for vertical mergers that was absent previously. They're clarified how the agencies would deal with nascent and potential competitors. Again, a previous blind spot. It addresses mergers that entrench a market position, going again to your comment, Chair Hübner, that it's not simply current effects on price or working conditions for workers. There can be future effects entrenching a dominant position where the adverse effects are more distant and maybe harder to predict as a result. Let me jump through to point out that there's a discussion of buyer power, so-called monopsony in economics, and wage effects, making clear that these are subject to the same standards of examination for whether a merger adversely affects these parameters of the labor markets. And the guidelines also explain how mergers involving platforms and innovation are analyzed. I'll discuss some of that briefly, and my colleagues on the tech working group will talk more about that for sure. To be clear, the merger guidelines are not law. They're not even regulations. They're simply declarations by the two agencies of how it is that they evaluate mergers, and their power, their legitimacy depends on their acceptance by the courts. And that really depends on whether the agencies can explain successfully to the courts what they mean and how it is that they apply in particular factual settings. Otherwise, the courts are left with nothing but the broad language of the law. So the guidelines are an effort to bridge that large gap by providing operational guidance about the application of those principles to specific settings.
I could just add a point here again to emphasize where these decision nodes occur. So if one were to think that antitrust enforcement has been underwhelming over the past couple of decades, and that these new initiatives to enhance enforcement are welcome, if one were to take that view, then there are some decisions to make, like, well, are the new federal guidelines sufficient enough to make those changes? Or will they be susceptible to changes over time as different administrations cycle through with their different priorities, or resistance from the courts? Whereas if one were to build out a framework for mergers in California, you wouldn't have the same agency dynamics, and you would have a different set of courts, even if you had adopted the same merger guidelines in California as were adopted by the federal government. So whether those are important things to change, or whether the federal process should work itself out in the way that it appears to be doing through these very guidelines, those are important considerations.
Can I ask a question?
Sorry.
And kind of going back, are these concerns, these issues, are they new? I saw that it said the studies are over the last 25 years or so. Have these issues always existed? And then studies brought it to light? Or was there a change in policy that made these issues appear? Is there a way to know if there's a change, or it's always been like this? Is it the rise of tech?
So in short, the process, as my colleague pointed out, is that there have been kind of waves of change over time. And so with the Chicago School and then with the post-Chicago School, there's been a transition period while the courts are acquainted with the new policies and standards, and practice changes as a result. So for example, the study that I did was accumulation in recent years of a long-term change in policy. And what it did was to, in my view, and the view of some other people, not everyone agreed with my results. We are economists after all, and so we're used to controversy. But the results of my study would show that the effect of the preceding standards was quite permissive in terms of allowing these. And so that was a gradual change over time. So I think my original study when it came out was an effort, not an effort, but the result of it was to highlight what the implications over time had been of the new regime. And just to fast forward a bit, I think that conducting research along these lines is really very important for the federal government as well as for the states to understand what the effect of policy is. Without that, what dominated discussion was arguments in economics and maybe in the law about some principles about whether we emphasized efficiencies or market power sufficiently. But at the end of these are empirical questions, how it is that the agencies drew a line between the benefits and the anti-competitive possibilities of mergers. And data, good empirical work, is incredibly important and in fact casting light on that crucial question. But as my colleague pointed out, the working group is in agreement on the importance of state authority to review mergers. This would bring cases of special importance to California into closer scrutiny. The states typically have better information about local market conditions, sometimes assess issues differently, as has been pointed out, and chooses to emphasize matters that are of secondary importance, not ignored necessarily, but of secondary importance to the federal government's review. It's also true that a state statute would provide for continuity. Again, the guidelines, as I mentioned, are not law or regulation. They can be reversed or ignored by the courts. They can be reversed with any change in government regime or authority. And as a result, they do not provide continuity in the same way that a state statute would. So we have seconded the idea, not a new one with ourselves, our working group, that the Cartwright Act could be amended in a couple different possible ways to specifically cover mergers. The terms trusts could be expanded or elaborated on to include mergers and acquisitions, or the language of the Clayton Act could simply be reproduced and integrated into the law. These are important matters in establishing the authority of the state to investigate these mergers on the same basis as the federal government does, but independent of the federal government's efforts in the same regard. So we have urged that. We've urged that, and I think others have as well, as something that would improve the authority of the state to take action in these circumstances.
If I could just add something, I think an important dimension to keep in mind is the distinction between notification and enforcement, right? So the discussion earlier on was ways in which the states could become better notified of mergers that affect the state that are currently being filed through the HSR filings. But other mergers that are important to the state would not come to their attention through HSR, right? You pointed out the anesthesiologists. And so if a state is thinking about, and many states have their own notification schemes, Rhode Island, Massachusetts. So if a state is thinking about expanding its footprint in mergers, it has to think about notification as well as enforcement, because the state AG needs to find out about whether this anesthesiology merger is taking place and what's the size and what are the markets that it can affect. And so a state could say, we just need better notification of mergers in our state. And then when we want to enforce them, we'll enforce through federal law, because they would always have the authority to try to block the merger under federal law. Or a state could say, we need better internal notification of mergers that affect our state that don't come under the HSR filings. And when we enforce, we need to be able to enforce in state court. Some states, especially for healthcare, have very streamlined procedures whereby the state authority, like Massachusetts, can block a hospital merger without a lot of procedure. Right, so there's a lot of variation out there in terms of what states do with their schemes. They involve notification, they involve enforcement, and within enforcement, there are various ways in which the enforcement can take place. Does it have to be with a civil case in a state court, or can it be through a more streamlined administrative procedure that then gets appealed to a state court? Right, so once you decide as a state to have your own merger scheme, there are a number of dimensions along which decisions have to be made.
This is not directly related to what you've just said, but for me, it's a cross-cutting concern. Do you have an opinion on the efficacy of state competition laws, given the theoretical option that any company which is unsatisfied can always move to Texas?
So I think any state with a scheme in place like that has to worry about, without having a view on it.
Yeah, but have there been any studies about the I don't know what the word is, the incident of companies fleeing to Texas because they want no regulation?
There have not been, and I would conjecture one of the reasons why is that states that do this do not enforce against companies with light feet. That's right. So for example, the hospitals in your state have to locate in your state. And so you see this in healthcare, for example, where we're not concerned that the hospital is going to move to Texas. And so we can have more robust state enforcement in the healthcare sector. But if it's going to be telecom, then you can see why this would be an issue, which is why when states do decide that a telecom issue is an issue, they proceed in concert with other states and they proceed under federal antitrust law. And either they get the FTC or the DOJ to go along with them, or sometimes they go alone. Like the states went after you'll know this better than me, the Qualcomm, T-Mobile Qualcomm merger, Sprint T-Mobile merger, right? That was state AGs doing it collectively under federal antitrust law, right? With the understanding that no state could do it under state antitrust law for the reasons you suggest.
Let me also add that if we could fast forward 2 slides to Roman numeral 3, this is what my colleague has just discussed, the role for pre-notification, okay, which does go hand in hand with but in principle may be separated from the issue about adopting the Clayton Act or some such. So I think the working group was in agreement that establishing a pre-notification standard in the case of California would be worthwhile for several reasons. In addition to the ones that were mentioned, the federal statute requires pre-notification of mergers over 110 or 120 million dollars at the moment. But there are economic studies that show a number of mergers that fall just below the threshold have gotten through and have not received the same kind of scrutiny and have been distinctly anti-competitive. Now, one can envision the possibility, and one of these cases has been documented in one of these studies, that the parties deliberately consummated their merger just before they cleared the threshold so that it was not HSR reportable. That doesn't mean that it could not be reviewed by the federal government if they were aware of it, but this did give them a head start and running room to declare their merger consummated before the agencies got wind of it. So a lower threshold, one that better reflected perhaps local market conditions where lower dollar thresholds are appropriate, would be an obvious way of doing this. It's also possible to expand notification to other sectors if there are specific sectoral considerations, as there are in the healthcare sector here in California. But also, again, you have them for certain retail, pharmacy, and supermarkets. Or as Mr. Robbins has suggested, if the ULCs pre-merger notification act is adopted, it could be adopted subject, of course, to the higher, more stringent standards specific to sectors.
I have a question about that. For those that you mentioned, mergers and acquisitions, were they concentrated in a specific industry?
The ones that were just under.
Yes, where you say they're,
Not that I recall.
Okay.
That's a good question. I do not.
and I know earlier you said over 900, right?
So I
That,
do not recall if there was a sectoral concentration of them. That's an interesting issue.
yeah,
Obviously, large mergers would almost automatically, and large sectors would almost automatically clear the threshold. So they were, and likely to be the anesthesiologist example who we're picking on today, or something similar, where otherwise it would not clear the threshold. But these were companies that, for example, engaged in roll-ups, and what they did, they did a series of mergers up to that point, and then paused to try to consummate them before any further mergers that would have cleared the threshold and required HSR reporting. So that's a concern at the federal level right now, but it's also one that has special importance to the state of California because local markets are typically local dollar values for many of the markets that are at issue.
Is the reporting threshold something that's set by statute, federal statute, or is this something that's set by regulation?
It's set by statute and adjusted for inflation. So it now is an automatically increasing dollar value so as to prevent it from, there was a point in time where it was set by specific action of the agencies. And as a result, as you're concerned about, it would end up being less and less relevant, but that's no longer the case.
If California wanted to set its own, have its own merger review reporting, how would one go about determining what a threshold for reporting?
So that would require some reflection and study to see the relative, exactly, to see the kind of sizes of mergers that may be occurring in the state of California, and to adopt a number. There's some arbitrariness to this, of course. Some adopt a number that would be caught, but would escape the federal standard. One wouldn't want it too low for all the reasons that everyone has agreed. The state does not want to be overwhelmed with a large number of cases.
Right.
The state can take action against a merger of any size, but it does need to be aware of them. And if it isn't, then I'm doing a study now about the difficulty that the federal agencies have in addressing consummated mergers. For obvious reason, it's partly unscrambling the eggs. And then if one can't do that, sometimes you can, and sometimes you can't. But if you can't, then one is typically left with less effective remedial action, and that's a problem.
And to follow up on that, the amount is interesting, but also isn't it also a question of market power? And doesn't it depend on the sector or industry? How much? So the amount is not just a static amount, but you have to do an analysis of the industry, the sector, to see what market power is yielded by that kind of a merger or acquisition.
So if data were available on concentration in shares, then one might write the threshold in those terms, because that, of course, you're quite right, is the concern. But that's hard to do, and that's really the next step that the agencies do. So for initial purposes of declaring that there's a merger of the size that might raise competition concerns, it's simply a dollar value. The first thing the agency will do is to examine whether there is what the market shares and concentration are. The federal agencies get somewhere between 2,000 and 3,000 reports of mergers under the current standard per year. And they conduct investigations of only a small fraction of them, because most of them, for the reasons you say, may be large, but they are in large industries where concentration in shares don't necessarily raise a concern.
States can also proceed sector by sector. So you have a number of states with specific statutes that respect to healthcare and hospitals, because they know every hospital merger is probably important in some way to a local market. And there also aren't so many of them that they would be overwhelmed by the numbers, so they can actually take a look at every one, or at least give it an initial screen.
So we could back up one slide, please, Megan? Thank you. So most of what I've just discussed has not been controversial within the working group, but some things are. And staff not only invited, but urged that we talk about those today. So here we go into the maelstrom of issues that were discussed on which there are differences of opinion. And as this slide says, there's discussion at the federal level that has implications for possible state statutes on other strategies for dealing with concentration and mergers. One discussion, as I think you know, is there's discussion or proposal in a bill that's been around at the federal level for a while to change the standard from substantial lessening of competition. It says significant here, but that's a typo. Instead of substantial lessening of competition, to change that to material lessening of competition. The idea is the following, or the rationale is the following, that over time, federal courts have raised the standard of proof that the agencies are forced to produce in order to enjoin or block a merger. They require, some people would argue, I would too, from my experience as well, that they require a much higher burden than the likelihood standard that's implicit in the current Clayton Act, and require something that's close to a demonstration of the high likelihood. And so instead of may and substantially lessening, the idea would be to reset this as a signal to the courts that all that was initially intended by the law and all that should be interpreted as the meaning of the law is a material, a non-de minimis lessening of competition. So I've given you the rationale for this. The argument against it, of course, is that this would empower the agencies to challenge too many mergers, including a larger number that raise no substantial or significant competitive concern. It also has been argued that this, would empower the agencies to challenge all sorts of things, whether that are non-de minimis, as a result of the giving essentially too much discretion to the agencies. That legislation with that provision has been introduced, and I think is going to be introduced again by Senator Klobuchar as a method of resetting or recalibrating the standard that the courts interpret as may substantially lessen competition. I'll leave that to, there was discussion about this within our working group, but there was no consensus on whether this is necessary. And again, it is a response to the rising standards that the courts have insisted on. The rising standards are partly the fault of my profession, economics, which in some cases has been able to demonstrate with some clarity the likely price increase. But that demonstration that models and economic analysis can sometimes do that has invited courts sometimes to say, well, you did it in this case, unless I see it here, I will not be persuaded. And so that disparity, and in some cases, economic models are simply not adequate to do that, is why it is that the agencies feel that the standard everywhere where it's appropriate and where it's not has been elevated in a way that makes demonstrating the possibility of some adverse effects on competition. That standard has risen to the point of being very difficult to enforce. And there are many examples of this, which I'm happy to provide to you or staff at some point where this appears to be the case. A second area, not entirely distinct, that was discussed within the agency.
I want to add
Please.
a third view on this issue of changing the language. One view is that, I would associate myself with the changing language like that doesn't affect courts. It doesn't affect what they do. A judge can take a material lessening of competition or a significant lessening or a substantial lessening, and they're going to view cases.
Professor, do you have your mic on?
They're going to view cases in the same way. For example, the language of the Clayton Act hasn't changed in almost 100 years, but courts over time have interpreted it in quite substantially different ways. And so one view would be it's not worth spending political capital on language changes of that nature.
Let me go on to the second one without further comment on that. That's a fair point. The second one may fall in the same category, I suppose. And that is that there's discussion about activating it's kind of a dormant part of the Philadelphia National Bank case decided by the Supreme Court in the 1960s. Philadelphia National Bank case, in that case, the Supreme Court opinion said that in an otherwise concentrated industry, a sizable merger can be presumed to be anti-competitive in the absence of clear evidence to the contrary. And this would substantially shift the burden so that the agencies do not have to prove, as they now often do, that even a 3-2 merger or a 2-1 merger nearly to monopoly, the agencies need to prove or establish or show evidence of likely anti-competitive effects. This dovetails with a concern that I mentioned before about a substantial lessening being the high standard. There are cases where the agencies seems to have to prove the obvious, and a presumption, a well-crafted presumption. There can be presumptions that are poorly drafted and do harm to the antitrust process, but a well-crafted presumption can allow the agencies quickly to deal with mergers that raise obvious competitive consequences. And in the language of the court, where there is high concentration and high shares at some level, there can be a nearly irrebuttable presumption that these are anti-competitive. I myself and others have conducted studies of, how many 2-1 mergers to monopoly are not anti-competitive. And, the fact that the agencies still have to go to court in some such instances and try to establish the likely competitive effect is a burden to the agencies, a waste of resources. And a presumption can create a bright line standard that some companies would value as well. So that, and there is court precedent that allows for this. Our report, written by people who are not necessarily of the same persuasion on the chart that was described between free market and neo-Brandeisian as myself. So our report says that that the federal courts have basically ignored the Supreme Court opinion in the Philadelphia National Bank that would empower the agencies to do this. So this could be resurrected in language that the state of California might choose to adopt. And the argument against it, of course, is that it would is the possibility that it would capture mergers that are beneficial just because they fall within the presumptive illegality standard. But again, the key to this would be to craft the presumption in a way that minimizes the likelihood of those type of errors while relieving the state AG from the burden, again, of, as I call it, sometimes needing seemingly to prove the obvious. My third bullet here, it says, and this has been discussed, is that there could be a prohibition on acquisitions by dominant firms. Again, a dominant firm would have to be defined in some fashion, but the concern here would be to prevent dominant firms from further increasing their dominance or entrenching their market power, that they would face a different burden of proof than, in fact, a possibility of an outright prohibition from mergers that they might otherwise engage in. Fourth, and not inconsistent with the above, is to sort of shift the burden of proof. So the mergers over a certain size or mergers in industries with certain types of characteristics like high concentration, those mergers would have to make an affirmative showing of the benefits of the merger, which would shift the burden from what the agencies now face, which is to prove or do their best to prove the actual anti-competitive outcomes. Shifting the burden would say the merger in these particular circumstances, high shares, large firms, would have to establish that they will not be anti-competitive or actually result in benefits to consumers or workers or some other indications of the purpose of the law. Please.
Is that essentially putting the consumer welfare standard into the merger decision-making or enforcement? I mean, it might be okay to have an anti-competitive merger as long as there's some consumer benefit to it. I mean, is that
So,
kind of a structure?
excuse me, so unless consumer benefit were written into the provision, it would not necessarily be limited to that, right? So
Yeah.
it could be, so long as there's an affirmative showing of benefits, the benefits would need to be spelled out. Again, there could be worker wages and working conditions just as much as there could be prices. But there are other statutes and other industries where the statutory or the regulation requires a showing of public benefits. So for example, the Federal Communications Commission has review authority over certain types of mergers in telecom and related businesses where there's a public interest standard, one prong of which is competition, but only one. There are other values there. So we are not here. I'm not here certainly to suggest exactly what that language should be, but it's not necessarily simply the consumer welfare, unless that is the way it is chosen to be drafted. That would not be my preference, but again, the idea would be to shift the burden. There's a certain amount of burden shifting now as a result of some federal judicial decisions where the agency first shows prima facie case of anti-competitive effects. Question is how much needs to be shown, after which the parties have the burden of showing, of trying to rebut that. This would go farther. This would begin with the parties needing, for these types of mergers, having the obligation of establishing an affirmative benefit. And again, this slide and my own views do not specify exactly what the benefits would need to be.
I think it's fair to say for most mergers where there is some significant concern of an increase in concentration, the approach over the last 30 years has been to say, well, if you can show that there's going to be no impact on consumers, or you're going to show that consumers will benefit, then that's a reason to not challenge the merger or to not block the merger. And so in practice, there has been a kind of concentration screen. Then we ask, okay, does the concentration screen suggest an effect on consumers? If it does, we block. If not, then we proceed. So I don't know if that's helpful as far as.
I think so. I mean, but it sort of gets to the underlying philosophical question about, well, is it okay to engage in anti-competitive behavior if someone else benefits, if it's a consumer benefits or maybe labor benefits, I don't know, which almost gets back to, the wealth of nations, that the whole purpose of doing this in the first place presumably was to have a competitive economic, a competitive economy where it's the competition among firms that results in efficiency and benefits to consumers and stuff, as opposed to, well, you can take anti-competitive actions as long as you can prove that somebody benefits. And those two philosophies seem to me to be sort of in conflict. I mean, that's why I think there's some controversy about the consumer welfare standard in the first place. So that's what I'm trying to understand.
So, I personally, this is my own view, have argued that the consumer welfare standard is too narrow. It's too narrow for some reasons, like it doesn't reflect wages, most obviously. It just doesn't capture them. And there can be wage effects that are anti-competitive pretty clearly. Speak to, when we did the merger guidelines, before doing the merger guidelines, the two agencies held listening sessions where people from different constituencies were invited to talk about how mergers affected them. And these were quite telling because we heard from farmers, we heard from nurses, we heard from an awful lot of people who were adversely affected by mergers, but not as consumers, right? I mean, they were adversely affected because of buyer power. And so, it's not, the lens needs to be broadened than the consumer welfare standard. That was a way of framing the antitrust laws that was promoted by the Chicago School, and
Right.
dovetailed with their view, but it was too narrow a lens because it did not capture some things. It also was a poor device, in my personal view, for capturing effects that are postponed into the future, because it suggests that somehow the agency should be able to project or estimate the adverse effects of a merger now, 5 years in the future, because it may be that far postponed. So eliminating a potential competitor, for example, that concern kind of died because the Supreme Court insisted on a demonstration of the effects that could not possibly be met because it was too speculative, too much in the future. So, and the law doesn't say anything other than lessening of competition. So my argument, and I've written about this, is that consumer standard is appropriate where there are immediate price effects that are the key to the competitive concern. Then it's a standard that is useful, but for many other parts of the anti-competitive, waterfront, including worker wages and effects that are postponed into the future, it's poor guidance. And it means that the agencies face a burden that they cannot meet. And the law doesn't say consumer welfare at any point or place.
Right.
I think the law, in a way, is also an answer to this question of, can someone do something anti-competitive, but then say it's okay because it helps consumers?
Right. That's
You can't, because if it's anti-competitive, it's illegal. Now, if a market goes from 3 firms to 2 firms, the concentration has gone up, the shares has gone up, but that doesn't legally mean it's anti-competitive, right? Or at least under the current law, right? It just means the shares have gone up, unless we're going to define anti-competitive to mean an increase in shares. They're distinct things. Let me give you an example. Would we say an economy that had 100 firms, each with a 1% share, and who made the same product every year with no improvement at the same price to consumers, would we call that a competitive economy? Or what if you had 5 firms in a market, each of which innovated in product and variety and so on, even though there were 5? Which one would we call more competitive, right? What is competitive is, we're not going to be able to define it here. That is the question that the law seeks to understand,
right.
in a kind of case-by-case method. But we can't say something harms competition, but yet helps consumers. Therefore, it's okay. We can't say that, at least.
Okay. Okay. Thank you.
Yeah, a couple additional thoughts consistent with that. One is, as my law school professor knows better than I, the Supreme Court has said that an anti-competitive merger is not rescued by a demonstration of efficiencies. And the merger guidelines have always said that they either don't or nearly never will weigh efficiencies in some other market or benefits in some other market against an anti-competitive effect here. And the reason for that is that once out-of-market benefits are allowed, there's just no end to the type of discussion that can be had. It's an invitation for all sorts of things to be raised and debated endlessly. And again, for operational reasons, it's not a metric that serves the process at all well. Let me conclude with a final bullet here, just to say that in the discussions within the working group, it's pretty clear that there are concerns about the practical side of any and all of these things that I've mentioned here. Consistency with federal standards would raise the possibility of inconsistent standards that single companies have to meet. I know what companies, I've talked to companies, I know what they think of that, and there's some legitimacy to that concern. Some mergers have had to deal with a handful of jurisdictions, counties, states, national authorities, international standards as well. Dealing with multiple standards is not, other things equal, is not efficient at all. There is the issue about the resources available to this or any state to be able to undertake the necessary analysis of some of these mergers. And there are other issues about, whether the states will be able to enforce this. So there are concerns, not the least of which, like I say, has to do with multiple enforcement standards.
I have a question.
Other,
Do we have any information from the state AG on the resource issue? Has he taken a position?
from California?
California.
Yeah, so I made some inquiries to the state of California. We were AG's office. We were, I think, advised that they should not to talk with them. I think that this inquiry was supposed to be relatively independent, and so that those conversations that I try to have, asking questions like that, just as a factual matter, I do not have clarity on that.
I wanted to add one point on sort of some of the views above are about burden shifting, but one thing that's distinct is this prohibition on acquisitions by dominant firms. And I think one point of discussion among the group, and it's especially important to California as an innovation economy, where many small firms sell themselves to large firms. And so that's an important part of the startup process and of the innovation process. And the dominant firms, in a way, have infrastructure that just can take these ideas and bring them to market. They've got the marketing, they've got the product engineers, and they have the business infrastructure. At the same time, there is evidence, and I think John is very close to these studies, showing that many of these dominant firms buy new ideas and then don't develop them because they don't want them to emerge as future competitors. And so there is a mixed bag of activity that is going on in this innovation sector, where the dominant firms are enabling some innovation and products to get to market and startups to form, and they are preventing others. And so whatever antitrust policy is applied in this space is very delicate, because one doesn't want to, it was the golden goose, right? One doesn't want to kill the golden goose. At the same time, there may be some abuse of dominance that's taking place.
Executive Director, a question.
Sure.
This is the primary agenda item. We have an adjournment at 5 o'clock. How are you proposing we move through this special order number 4, including breaks?
So we have mergers and acquisitions, which I think is about done.
There's one more slide,
One
part
more
of which
slide.
my
And then
colleague
we-
has just surveyed, yes.
And then we have technology platforms, which I think will take roughly an hour. Is that correct, David? Maybe
It could be less in terms of our presentation. It really depends on
on the questions. So what we could do is get through these 2 expert reports and then break for lunch. Or
And that'll make it a long afternoon. Why don't we get through the current report, take a 10-minute break, and then come back? Given the technology platform group's representation, they don't need really the full hour. And then when you're finished, then take the lunch break. Does that make sense?
that works. Does that work for?
Does that work for the 2 of you gentlemen?
Yeah.
Okay, so let's wrap up the M&A and then take a short break so commissioners can stretch and refocus.
Before we leave this slide, can I ask one question, please? During your presentation, you called it the distinction between material lessening and substantially lessening, but your slide refers to significant lessening. Am I correct that significant is the same thing as substantial for the purposes of?
In the slide, it says significant, but that was a typographical error. The language of the law says substantial lessening. So the contrast was between substantial lessening, the law, current law, and material lessening. And I think definitionally, material is smaller than substantial. My colleague thinks that the judges will ignore that, like they've ignored a lot of other things, and that may be true. I cannot, he can perhaps better predict how they will interpret that.
Okay, thank you.
Chair, may I ask a
Last slide,
question?
please.
May I ask a question?
Please
too?
do.
Okay, thank you. Thank you. Hello, my name is Catherine Blakespear. This is my first meeting. I serve as a state senator from San Diego and Orange County and worked as an attorney for 15 years before being elected. And I just wanted to offer, if you could go back to the slide before this one, that I do think that taken together, the standards of review and those 5 bullet points would make a substantial difference as an indicator to agencies and then interpretation by the courts. The description of material versus significant to me did not mean anything until you said it's anything other than de minimis lessening of competition. And to me, that de minimis is a very clear term of art in law. And so it leaves the other 98% as saying, if that's happening, then it actually is a lessening of competition. So I think redefining these terms, and I understand they're all individually potentially under discussion, or there's not a consensus among the different voices about whether they're a good idea, but I do think it would make a big difference taken together. So I just wanted to offer that as commentary. Thank you.
Thank you. And again, the last slide, please, which Prasad has largely surveyed already. The report says, we all know that mergers in this sector can have different types of effects. They can impede innovation. One company can acquire the other in order to abandon the target company's parallel innovation that threatens to cannibalize their own sales. There's a recent study that's been done by 3 prominent economists that show in the pharmaceutical sector nationally, examining thousands of cases, that somewhere in the high single digits as a percent, the result has been to shut down the target company's competing innovations. This is a so-called killer acquisition strategy. So mergers can certainly do that, and the economic incentives are clear. It's also quite clear, equally clear and indisputable that mergers can combine complementary capabilities in the innovation space and facilitate their consummation. So it is trickier than for a lot of traditional manufacturing sectors. It's trickier to analyze mergers with respect to their innovation potential. The merger guidelines have language in there, which I'll have to say, it may not be as precise as as some might wish in those terms, but it focuses on this very question about whether the innovation displaces something that otherwise would have occurred, and uses that as the guiding principle for when an innovation a merger involving innovation may be anti-competitive. So let me leave it at that, because that's a subject for a very large discussion, which will leave us all equally baffled at the end, as we are now. And with regard, there are other issues, of course, raised by platforms and innovation, which the tech sector folks to my right will take up. But this completes our report. Thank you for your attention, your questions. Happy to answer other questions now or subsequently if there's any interest in that.
Any further questions for this panel from commissioners? Hearing none, let's adjourn for a 10-minute break and be back about 5 to noon, and then we'll invite our next panel to speak. Thank you.